Okay, thank you all for being here. It's my pleasure this afternoon to introduce Professor George Pavlakos, who is the Director of the Centre for Law and Cosmopolitan Values at the University of Antwerp and also holds a cross-appointment at the University of Glasgow. George brings with him extensive expertise in jurisprudence, which for us today he's going to bring to bear on the challenge of explaining law beyond the state in a paper which is written, I think, initially as a response to the intervention that Dworkin posthumously made to explaining the philosophy of international law, but which takes us a long way beyond Dworkin's own contribution, I think, in offering a very plausible theory of his own. So I won't speak any further, but thank you, George, for being here with us, and we look forward to your paper.
Thank you so much. I would like to thank Andrew, the entire legal theory group, for this fantastic invitation, which gives me, by the way, the opportunity to travel east of Istanbul for the first time in my life. So it's great to be here. And also for inserting me in such an illustrious line of speakers, which is a great honor for me. Right, so what I'll try to do, the paper, as Nicole pointed out, indeed covers a lot of ground, even though it uses Dworkin as a starting point. So what I'll try to do is I will first broach a number of what I call puzzles in order to introduce some more familiar problems, perhaps, to those who work in the field of international law more concretely, which initially gave rise to some reflection, which led me eventually to come up with some of the ideas of the paper. I should say that a bit of that reflection was conducted together with my colleague Joost Pavlakos, who is, well, he's Flemish in origin, but he works in Geneva right now, and who is a real international lawyer, a title that I cannot claim for myself. So here are some problems or puzzles. How are states obligated to international law? I mean, this connects directly with Dworkin's recent contribution, where he points out that often consent, which is what the standard picture in international law takes to be the ground of international law obligations, will not work. And of course, the counterexample is that often in customary international law, we have a custom part which obligates states which have not been part of the customary practice or the practice, the longer uses and the opinio necessitatis. So if not consent, how are these states obligated? A second question which I've noticed is being raised often these days is some puzzlement about the subject of international law. So instructively, I mean, as we know, again, under what allow me to call the standard picture by grouping together too many things, the state is prominent, or the main, or the sole, rather, subject in international law, and this picture has been challenged. I give you a case of where individuals enter the picture. There is this rather famous in Europe case, the Caddy case of the European Court of Justice, whereby the European Court challenged a UN Council resolution. Now, the facts of this case, because it might be helpful to use it later on for the debate today, are that Mr. Caddy, who I think was residing in Sweden or Denmark, I'm not absolutely sure, one nice day he went downstairs from his flat to the ATM to get the first money of the day to enjoy his first cappuccino, I don't know exactly, and the ATM started flashing, you go to manager. So he goes to the manager, he discovers that he cannot withdraw money. The reason was that his name had been included in a list that the UN had produced which ordered that the accounts of the persons listed there be frozen on the suspicion of involvement in terrorism. Now, to cut the long story short, this case reached the European Court of Justice, and the European Court of Justice basically challenged the UN resolution by roughly saying, to the extent that the European standard of human rights protection is higher than the standard incorporated in that particular resolution, this resolution, this legal norm does not produce the obligatory effect on CADI that it purports to. So, in other words, this was a kind of case whose structure we see very often in Europe. Classical examples are the so-called Solange decisions, judgments of the German Constitutional Court, where we have the phenomenon of the German Constitutional Court challenging the EU legal order on the grounds that the standard of protection of human rights in Germany, in the German basic law, is higher than the European one. And the cases have taken the name from this clause that the court spelled out, saying that European law will not obligate Germany as long as it does not respect the same standard. So the langue is, as long as. Sometimes French Erasmus students tend to pronounce it the Solange case, which is always funny to hear. But that's actually the same structure there. And now I can use the same cases to address the third problem, the problem of the hierarchy of norms in international law, by which if you look at it from a different point of view, concerns the question of the unity and the fragmentation of legal orders in international law, which again seems to provoke a lot of discussion amongst international lawyers. The same cases can be used here because precisely we have a lower legal order, Germany or the EU, stepping up and challenging a higher legal order, if we may put it in those terms. And the question is on what pattern, is there a coherent explanation of such exceptions from the hierarchy of norms? So the suggestion of the paper is that there is something like a global order of legal obligations. So I'm just going to put forward the preposterous claims without defending them at this stage and simply talk about them as we move on. These obligations are enforceable obligations, even in the absence of institutional enforcement. This is a claim I will make towards the end of the paper, but it is important to spell it out now. So the way I see it is that this legal order or order of obligations underpins the so-called crystallized institutional orders in such a manner that those, when they enforce law, they all enforce the same set of global obligations. So the existence of this underpinning legal order speaks for or supports some idea of monism in international law. So you have one set of obligations that can be enforced from different points of view. Now, this monism is not formal, if you allow the term, precisely because as I tried to say initially, it purports to explain discrepancies in the hierarchy of norms. So it cannot be a formal monism in that sense. Otherwise, it would be defeated. It's a substantive monism, or that's how I would like now to label it. Now, the third feature of the obligations in that order is that they are grounded on a particular normative relation that obtains between agents, or groupings of agents. Now, instead of developing or reinventing the wheel in some sense about that normative relation, I will avail myself of the notion of the concept of political association, which Dworkin uses, I think, the first time more prominently in Law's Empire, and has used since more recently in that paper he published last year. That was published because he wasn't around anymore. That concept of the political association is what I want to take as a basis of my account and try and reconstruct it, because I believe that there are elements within it that allow for a suitable reconstruction to bring it beyond, as Nicole pointed out, beyond the Dworkinian, the historical Dworkinian opinion or conception of it. So I think that the main challenges for this account, this project, is first of all to show that there is such a thing as political association which goes beyond the state, which is actually very important for the grounding of the obligations I want to talk about. And second, that enforceability is something that is different from enforcement. Now, I should perhaps say here that this second latter move, basically what it tries to do is to argue that legality is not a compact property, that a core element of it is the idea of enforceability, and this idea of enforceability or instantiations of enforceability take place much sooner than the other component of legality, enforcement, or the component many take to be crucial to it. So let's move on to Dworkin's account. So according to the long-standing fight that Dworkin has fought against positivism, institutional facts cannot ground legal obligations. This is his central claim. Now, the concept of ground has been used by Dworkin early on, and it has been elaborated further more recently, also in line with debates in other parts of philosophy, such as metaphysics or metaethics. Basically, the idea is that when you look for a grounding relation, what you look into is an explanatory relation that is the strictest possible, generates the strictest possible explanation of the explanandum in the light of the explanans. So if I say to you just very simply that a body accelerates in virtue of some force that was applied to it, this would not yet be the strictest possible explanation, because there is another one, namely that accelerates in virtue of its increasing velocity over time, which covers the full conceptual space of the explanation. So this is the kind of relation that grounding is trying to establish. And some people more recently, in particular Nikos Stavropoulos and Mark Greenberg, who have dwelled on the demands of grounding on a theory of legal obligation, the demands that the notion of grounding poses for the explanation of legal obligations, have suggested that if you take a Hartian account, according to which the facts of a practice ground legal obligation, I'm cutting it a bit short here, this is not plausible precisely because no fact, no descriptive fact of a practice can determine, as it were, standards for its own application into the future. So you may call it, if you are familiar with the debate or the idea, Kripken-Steinian objection, where one that lends or borrows from Kripke's reconstruction of the rule-following considerations in Wittgenstein. But that's the important thing is that descriptive facts cannot provide normative standards that will determine their relevance into the contribution to the content of the law. That's the full, because the content of the law, these people say, is normative. So for facts, any array of facts, to intelligibly make sense as grounding normative content, you need something else to read them, in whose light you need to read them. And that's the idea. So rules of recognition, basically this attacks the practice theory of rules as a whole, but in particular its legal part, the rule of which amounted to the idea of the rule of recognition in Hart. Rules of recognition cannot determine legal content in that demanding sense of grounding. And it would seem that Dworkin, who I think would be happy to take this further analysis on board, that Dworkin applies his conclusions from domestic law also in the international legal order. Because what he tells us there in that recent article is that a further fact about state practice, that is, facts of consent, cannot contribute to the grounding of international law obligations. So put any facts you want together, that will not determine the content of the law without further ado. Instead, he argues we should take on board the notion of an associative obligation, which again he used, as I mentioned, he used in Law's Empire in more detail. Having said that, I think there's not much to go by in Dworkin's work on what an associative obligation is. Well, there are remarks, but there's not a full theory. I should also say that even though associative obligations build up a large set of obligations, I will restrict this account here to political associative obligations, which I think is what Dworkin is interested in. Now, these obligations require a context of a political association. And when do we have a political association? We may discuss it further later, but the idea basically is that a political association takes place when there is the possibility of collective enforcement, which can be justified vis-a-vis everyone in this group of persons. Now, the collective agent who enforces, at least in the domestic level, is the state, and therefore the state is obligated by those principles that justify the exercise of coercion on the citizens. At the same time, the same principles ground legal norms which obligate citizens accordingly. Now, Dworkin seems to want to extend this beyond the state, but how? And this is interesting here. So, there is a movement from coercive imposition, let's put it this way, state coercion, to justification and then to the principles that justify coercion in Dworkin. And these are taken to be the principles that ground the law. But Dworkin says now, so the question is, which principles are those? Dworkin says that these principles include not only those principles that justify what the state does to its own citizens, but also principles that justify what the state does abroad. But to whom? That justify it to its own citizens. So the idea is that because the connection between coercion and justification is a domestic connection, the justification is owed to the people at home, but also for what the state does abroad. So I suppose we can think of it in terms of externality. If the actions of your government have a particular impact, well, a crude way to put it, if you are sending drones somewhere, you know, bombing people, I mean, this is a crude instance of an externality, but a lot of other things, impact on the environment, impact on trade, a lot of stuff could be put under this umbrella. So because of this expansion, then the principles that are being brought on board and obligate the state in its actions in virtue of the fact that it owes a justification vis-a-vis its own citizens, will also include principles about obligations the state has abroad. Human rights would be an instance here. Another instance, Dworkin says, is treaty and custom in international law, which now becomes binding on the state, but not because of consent, that's the difference here, but because of this bridge he built, the justification of coercion vis-a-vis its own citizens. So this is the expansive account that I think he undertakes in that paper. Now, I think it's fair to say that there is an element of statism that survives here in Dworkin's account, because everything depends on the existence of coercive imposition by the state, which, after all, as Dworkin told us before, it is still another fact, or it is one further fact about state institutional practice. And I mean, it's not that we find that not just in Dworkin, but also in other liberal thinkers in the area of political philosophy. The entire debate on whether distributive justice obligations extend beyond the state is premised mutatis mutandis on similar arguments, such as that distributive justice takes hold only when we have coercive imposition by the state. So the state is obligated to distribute, I mean, the state as a collective agent, to distribute precisely because it coerces the citizens. Nagel published a paper in 2005, I believe, that started off a huge debate in the field. But if coercion as a fact is really what does the explanation in this case, then after all, Dworkin hasn't gone that far from the standard model that he attacks, even though the emphasis now is on a different fact and under a different rationale than his positivist opponents. I have put down there the Angelical Society thought experiment that I think first surfaces in Finis and subsequently in Raz. And so in order to blow up the bridge of coercion, I mean the coercion as a bridge to justification, Raz proposed that thought of this, made this objection. He said, suppose we have an Angelical Society, no coercion is needed ever, so how do you connect the law to the principles that justify coercion, if coercion is? And I think this is a way of reiterating the objection at that level, also of international law, if this is how it works, and also for the theories also for the debate in political philosophy. So let me now make a short digression, which I hope will be helpful. Now, it seems that there is a parallel debate between law and political philosophy when it comes into inquiring into the grounds, as it were, of obligations. And now, so there are two ways to conduct this inquiry. You can do a site-oriented inquiry. So you're looking for the site of justice, the site of law. And usually this inquiry is an inquiry into existence conditions. So you're trying to create a list of conditions which, when they obtain, then you have law, then you have justice, if I may put it as generally as that. And this is purely a description of phenomena now. What the researcher or the inquirer does in this case is they take a functioning normative practice and they basically describe it, and they produce a list of existence conditions. Typical here is the project of descriptive sociology of Hart, but also what some people took roles to be doing when he was talking about the basic structure of a society that gives rise to obligations of justice. So now the opposite is a scope-oriented inquiry. What is it there? What you're looking for is to determine the range of persons who stand in normative relations, and they have reciprocal claims to one another. Now, these two projects can, they are both valuable and helpful. But what has happened for some time in both law and political philosophy has been that site-oriented inquiries have been taken to determine, so questions about the site have been taken to determine questions about the scope of the respective obligation. And this amounts to something that we may call it the site-scope identity thesis, according to which when the criteria about the site obtain, we can determine the scope of the obligation. That is, the site overlaps with the scope. Abizadeh, who wrote an interesting paper in reaction, I think, to Nagel's paper even, in 2006 or 7, put it very nicely when he says, well, this is a substantive thesis, this identity, and has to be argued for. It's not an analytical truth. So to take the question of sight to be antecedent to the question of scope, I think is problematic. And there are advantages in starting with a scope-based inquiry. First of all, because of globalization, because of all the puzzles I broached earlier, at least, and my explanation may be not very principled here, but at least these puzzles raise questions about the priority or the ordering, the direction of fit between site and scope. And a second consideration may be the fact that if we take a practical point of view about obligations and what do they do with persons, we're interested in considerations that determine how persons normatively relate to one another. So how do their acts impact on others in a normative sense, in a practical sense? So I think there is also something to be said there, even though I haven't expanded on that much. So now, I should say, perhaps for those who are not very much in the global justice debate, that the question whether there is a global basic structure or not has been, tons of ink or computer strokes have been spent on that. Is there a basic structure beyond the state? Does the European Union have a basic? And the question is always, well, what does roles define as basic structure? These are the elements. Let's group together, produce a litmus test, and then see what falls within and out with that domain. And the challenge to that picture has come, to this type of inquiry, has come from political philosophy. This is why I think it is an interesting parallel that has not been explored enough, and why I bring it, I put it before you. So with that in mind, how can we produce a charitable interpretation of coercive imposition as a core element of the political relation, the political association relation? We should leave facts about enforcement aside and think about something else. I'm not so sure about the formulation, but the idea is, what we need to look at is how agents come to a normative relation to one another. So we need a structural account there. Because, of course, we're not going to be talking about particular obligations. We need something that goes beyond that. And I think this structure could have 3 levels. First of all, political association or this kind of normative relation requires something like practices where people, agents, can reciprocally direct each other's actions. So reciprocal practices of action and direction. Now, these trigger off something like a principle of justification. And that thing, in turn, grounds what I am looking for, the legal obligations minus enforcement. So the enforceable, what I call enforceable obligations. Now there is a mind-boggling formulation of a possible instantiation of this principle of justification. This is a constraint or condition that Julius put forward in a paper in the mid-2000s, in the mid-noughties, when reacting again to Nagel. And the idea is here, let me give you an example instead of reading that. So suppose you say to someone, here is a corridor with 10 doors. You can pick any room you want. But you have locked 9 out of 10 doors. So they enter only in room 10, or that door which is open. Now, what this principle says is that you shouldn't do something that is locking all the doors in order to get the other to enter the unlocked door and not give them a justification other than your locking of the other doors. So I think, so this is the idea of a practice that directs action, and of course, well, I call it reciprocal practice because this should obtain as a possibility between all agents involved, how that these agents can reciprocally get others to do things. And then there is this constraint, which is a principle of justification. And I think this arises in all contexts where you have this possibility, when you have action, direction, action. That makes the account not cosmopolitan in an abstract sense. So it is not the case that in virtue of being human, we trigger off justification vis-a-vis others and special principles. It needs engagement between groups of agents or agents, and the relationship, as it were, the metaphysical, well, allow me to call it this way, metaphysical relationship is that such practices trigger off the principle of justification, and that only later grounds the obligations we're after. I think it works, but of course I'm up for discussion. Now, and I think this is really what we have when we have political association. There's an objection from circularity here, which I will not discuss now. We can talk about it later if you want. I saw recently, it was brought to my attention by one of my graduate students, Scanlon, in his account of Promise, has dealt with a similar objection from circularity. So if you want, we can discuss it later. Okay, now enforceability. What I mean by this. So the obligations that are grounded, which I call enforceable obligations, have two features. They are joint obligations. So what I mean by that roughly is that by realizing the reason R, the obligation, one helps realizing it for everyone else in that practice. And they are enforceable. And the enforceability is a feature really, something like a feature of the modal operator. It's not a pure ought. You ought to X, but you ought and can be made to do X. So it's part of the meaning of the ought of such relational obligations that they give an authorization, a standing to others over your conduct. I think this is important. Right. So this authorization over the conduct of others within that group of people is a mark of enforceability. I suppose I could call it otherwise, but I think the idea is that, this ought to do X is already involves the claim of another. Finally, I would like to contrast this to moral obligations simpliciter, such as the prohibition of lying simpliciter. If I lie to you over coffee, well, if I boast that, I don't know, I'm on first name terms with Obama. You know, he's a great friend of mine, and we go and have a drink, and then he does this for me, and I discover later that I was simply lying. You know, you can reproach my character, you can, I don't know, whatever, but you wouldn't have a claim against me as you would if I lied in the context of a practice of assurance or reassurance. You know, I relied on what you said in order to base some project of mine. And that can happen even in a pre-promise stage. You know, there were indications that the two agents were in this kind of context of assurance. So I think there's a difference there. And I think this is also the difference that marks the distinction between law and morality in the way I want to conceive of it. Namely, if you move the bar, as I'm trying to do, more to, well, I don't know if the continuing line is law and morality, the standard picture. If you move it further afield towards morality, as I'm trying to do, yet you do not include the whole of morality. You know, there is a part of morality that is non-relational, which I think is not law. So I don't know if I'm fully right, but what Dworkin was trying to do in his recent book, i.e. to unify the universe, and everything is part. I mean, I don't think this is necessary, or I don't think it follows, to put it simply. Finally, I have a remark on Kant. Well, maybe I will just very simply say that Kant famously says that we have an obligation to enter an institutional legal order, to enter. So I think this account that I try to present somehow explains why we need to pass from enforceable obligations to instances of actual enforcement. There is, you know, there is an obligation to set up institutions. Some people have argued about that in the context of global justice again. Thomas Pogge, for instance, he says we should set up the right kind of institution in order to implement the obligations we have. But I'm not fully aware of the parallels here. And the final slide is about institutional enforcement. So where does enforcement remain? Where is it left? I think once we have, if we see the existing crystallized legal orders as enforcing the same set of obligations, then enforcement can be as pluralistic as you want. So, you know, if there is a, let's take the ECJ case, the Solange case of the German Constitutional Court. So there are those who argue that in Europe you have a pluralism surviving. So you have the EU legal order and then you have different legal orders, and what you try to do is coordinate a network or through translation, communication, whatever. But this pluralism might not be as deep as they take it to be. It might be a shallow pluralism of this sort I'm talking here about. So when the German court comes forward and says Solange, it is not saying from the point of view of Germany, this is the law. It simply says the law is this for all of us, and I'm enforcing it now. So what I'm doing is I'm enforcing common law for not common law has, the common principles for everyone. I'm just in a position to do it. Well, better or not, I don't know what you want to say about the jurisprudence of the German court. Once we had Kirchhoff, Professor Kirchhoff in Antwerp. Colleagues had invited him on a conference about the dialogue between high courts. And he was asked, so does the German Constitutional Court ever consult other jurisdictions like the ECJ or Human Rights, European Human Rights Court? And he said, German Constitutional Court never consults other courts because its case law is complete, I don't know, correct and eternal, so along these lines. You know, there are of course certain practices and mentalities behind them, but I think that the pluralism of enforcement can stay at a level that is relatively shallow. A few people have argued for that, and what might seem seemingly fragmented international law order, it's actually much more interconnected than we first took it to be when we aired those puzzles, when we spelled out those puzzles. So the issue of consent, I think, yeah, international law obligations are not based on, are not grounded on consent. I think that's fine. Subjects of international law, if you have a structure for the normative relation that is pertinent, anyone can be part of the structure. And I think really to have formal tests of subjectivity or subjecthood is like having site-oriented inquiries. You know, you try to find a definition, what counts as a subject in international law, and then I think this is taking things the wrong way around. So really, and fragmentation, as I already pointed out, should not be as deep as initially appearing. And finally, again, I repeat here this obligation to set up institutions of enforcement, some courts, international courts, other orders. But my thinking, of course, in this kind of the level of implementation is more rudimentary. So